Good afternoon and welcome to this QLS Facebook Live session in relation to the changes to the Youth Justice Act incorporating 17-year-olds. First of all, we would like to acknowledge the First Nations people as the original inhabitants of the land on which we are broadcasting this live feed here in Brisbane, traditionally known as Meanjin, the home of the Jagera and Turrbal nations. We equally acknowledge nations from every corner of Queensland and want to extend this to all elders past and present, as well as emerging leaders of today. We recognise, respect and celebrate the First Nations youth, the leaders of our future. I particularly want to acknowledge the contribution of many First Nations people, including the Aboriginal and Torres Strait Islander Legal Service, in achieving this law reform that we're discussing today, and express a deep desire that this law reform will be the first of many issues, of many reforms that might address the gross overrepresentation of First Nations young people in the criminal justice system. I'm Damien Bartholomew and I'm currently the Deputy Chairperson of the Children's Committee of the Queensland Law Society. And I'm a solicitor at the Youth Advocacy Centre, a community legal and welfare centre for young people who live in and around Brisbane. So today we're going to talk about the reforms to the Youth Justice Act, which will essentially incorporate 17-year-olds into the children's court system here in Queensland. We've indicated a time period of about 15 minutes, but this session's likely to go longer than that. So I'll probably deal with the significant issues at the beginning, and if people want to stay on board and continue to listen to some more details, we'll just keep going and hopefully work through the proceedings for today. So I'll start off by just giving you a bit of an overview of this change in the law and the background to it. I'll talk about some resources that are available for practitioners that might be particularly useful for people in their everyday practice. Then talk about how this change is going to affect new matters that are commenced after Monday when the legislation comes into place. We'll then talk about those existing matters that are currently on foot prior to the commencement of the legislation on the 12th of February. Then talk about what will happen with current sentence orders, then talk about young people who are currently in prison and the transfer from prison, as well as talk about appeal, and then talk about appeals. So just as a broad overview and some background to what's happening on Monday, as most people will be aware, when the Youth Justice Act passed in 1992, it provided a definition for a child to be a person under the age of 17, and that was contained in Section 6 of the Youth Justice Act. And Section 6 actually indicated that at a date in the future, by regulation, that the law could be changed so that a child would be defined as a person under the age of 18. And in a much quoted speech since at the time of the introduction of that legislation, it was indicated that that change would happen at a time in the future. So that would then make Queensland consistent with the definitions of a child under the International Convention on the Rights of the Child and with every other state in Australia. After a long campaign in which the Queensland Law Society played a significant role alongside many community organisations, finally on the 3rd of November 2016, the Youth Justice and Other Legislation Inclusion of 17-year-old Persons Amendment Act of 2016 was passed. The Act was assented to on the 11th of November 2016 and therefore usually would have come into operation last year. However, that was extended by regulation late last year, and the commencement, as a result of that, the Amendment Act will now come into operation on Monday the 12th of February, this coming Monday. So what the Amending Act actually does is it deletes that Section 6. So the definition of a child contained, and the definition that's contained in the dictionary currently of the Youth Justice Act, that's in Schedule 4 of the Youth Justice Act. And so what that therefore means is that the meaning of a child as defined in the Act's Interpretation Act will apply, because there will be no definition of a child actually within the Youth Justice Act. And therefore that Act, that standard definition of a child that's used in the Act's Interpretation Act of 1954 will apply, so that a child will be a person under the age of 18 years, bringing us into line with the rest of the country. The deletion of Section 6 also removes the transitional arrangements that were included in the original 1992 version of the Act, and so the remainder of the Amending Act largely provides the head of power for the regulation to then prescribe the transitional arrangements. And those transitional arrangements are now set out in the Youth Justice Transitional Regulation 2018, and that was published on the 30th of January this year. So we've only just got the regulation, which is why there's been a bit of delay in getting some information out to practitioners in terms of how this is all going to work. So first of all, I'd like to talk to you about resources that are available, and many of you will be aware that youth justice is now administered by the Department of Child Safety, Youth and Women. And you may be aware there's some information about this transition that is located on their website. And there's an update on their website about with some background information and some general information in relation to this. But most particularly, as of today, there are resources that are available on that website, and that includes an information brochure for young people about the changes, but most particularly information for legal stakeholders. So there's a 9-page document that is now uploaded onto that website, and this document is for legal stakeholders, and it provides a comprehensive guide to how the amendments will work, and people who are linked into this live session, that information will be provided to you at the end of the session. In addition to that, you'll notice at the end of the document that there is at the end of that legal stakeholder document that's been published by Youth Justice, you will notice that there is an email address there for the Youth Justice Practice section. And that email address, if you're able to access, practitioners are able to forward questions or queries to that section by email, and they've also provided a telephone number. So if you've got particular inquiries in relation to a matter concerning a 17-year-old and you've read their stakeholder sheet and you've perhaps spoken to a person from your Youth Justice Service Centre, you may wish to email the practice session, but they're also aware that issues do come up on the spot, which is why they provided a telephone number that you can call. So if you're stuck in court, you needed to go outside for a quick adjournment and call somebody, that number is available. But it's not equipped to take 200 calls on Monday. If you've got an issue, it might be a good idea to send an email. It would only be if you had an urgent matter that you might like to call that number. There won't always be someone at the end of that phone, and they said that if you do get an answering message, please leave a telephone number on which they will try to get back to you as soon as possible. Most particularly, practitioners should also be aware of the fact that Legal Aid has received some additional funding to accommodate this transition, and they've now got a legal advice hotline that is available from 8 a.m. to 9 p.m. Monday to Friday, and from 7 a.m. until midday on Saturdays to provide legal advice to young people about youth justice issues. The number for that hotline is 1800 527 527 or 1800 LAQ. And if you have clients who are on orders and they wanted some information and you mightn't have a grant of aid to be able to provide advice to them, give them that number. And that service is available in relation to all youth justice clients, not just 17-year-olds. So all young people who might have queries about the youth justice system, so that's from the age of 10 to 17. I understand there will also be 2 videos that are directed towards young people to assist them to understand these changes. I'm not aware of the date of when those will be up, but I suspect they'll end up on that website, which is the information that will be provided to you at the end of this session. So they're the resources that I think are available for people out there and that people will be able to use. I'll now talk to you a little bit about new offences. So if a proceeding is commenced after the 12th of February, so a matter is started after the 12th of February 2018, and the person was 17 years of age, then that under the new section 387 of the Youth Justice Act, that matter must be commenced in the Children's Court. So that means that any offence committed by a 17-year-old must be commenced in the Children's Court after commencement. That's section 387 remains subject to the existing section 140. So that means that if over 12 months has passed after a person has become an adult, then essentially if they're 19 now, if they're 19 in 2 years' time, those matters will still be commenced in the adult jurisdiction. And of course, none of those matters will actually be applicable as of Monday. But so essentially, if a young person commits, a 17-year-old commits an offence on Monday, any time after Monday, those matters will be commenced and heard in the Children's Court. Section 8 of the regulation also provides that the Police Powers and Responsibilities Act will apply to 17-year-olds from the date of commencement. So therefore, any young person who is interviewed by the police from Monday or after Sunday night really, or they must consider diversionary options, if they've got to take identifying particulars, all the provisions that would usually apply in relation to young people in the Youth Justice Act will apply to them. So that also comes into place as of Monday night. So that's all for new proceedings. I suspect what lots of practitioners are also interested in is in terms of, well, what happens in terms of existing practitioners, proceedings. The general rule for practitioners to be aware of is that pursuant to sections 14 and of the regulation, if you have a 17-year-old client who has a proceeding that is commenced prior to the 12th of February 2018, but has not finished before that date, that subject to a few exceptions, those matters will be transferred to the Children's Court jurisdiction on the first mention of that matter in the adult court subsequent to commencement. So be aware that that only applies to 17-year-olds who will be appearing in the adult court after commencement. So if you've got a 17-year-old, they've got a matter on foot, the next time the matter gets mentioned after on Monday or a date thereafter, the court will then transfer the matter to the Children's Court jurisdiction. If you enact for an 18-year-old who committed an offence as a 17-year-old, that proceeding was commenced before the 12th of February, that matter will not be transferred. So just keep in your mind, 17-year-old matters are being transferred. If you've got a matter that even though that 18-year-old, if they were charged for that offence after the 12th of February, that matter would have to commence in the Children's Court. If that matter was on foot prior to the 12th of February, the transfer provisions do not apply and it will remain in the adult system. Of course, any practitioner who was appearing for an 18-year-old who had an offence that they committed when they were 17 would be bringing to the attention of the court, that matter would now be dealt with in the Children's Court if it was being commenced now and bring that anomaly to the attention of the court. But currently, those matters will just stay in the adult court where they are. So how the transfer will work is that obviously if a matter's before the Magistrates' Court, at the next mention of the matter after Monday, the 12th of February, the matter will be transferred to a Children's Court constituted by a magistrate. So if it was before a magistrate, it'll be transferred to a Children's Court constituted by a magistrate. If the matter is before the District Court and it's a serious offence, as defined in Section 8 of the Youth Justice Act, so that's essentially those matters for which an adult must receive a period of imprisonment over 14 years, then that matter will be transferred to the Children's Court of Queensland. So all serious offences currently before the District Court get transferred to the Children's Court of Queensland. If you've got a matter that's before the District Court and it's a non-serious matter, then at the next mention, the judge will determine if the matter should be returned to the Children's Court to be dealt with summarily, or if the matter should be transferred to the Children's Court of Queensland. So the judge gets to make the decision. But it's likely that practitioners need to be aware that judges will be particularly interested in the views of your 17-year-old client in reaching this decision, because if the judge transfers the matter back to the Children's Court before a magistrate to be dealt with, or back to a magistrate to be dealt with in the Children's Court before a magistrate, Section 78 of the Youth Justice Act will still apply, and if the young person wanted to, they could then have the matter committed to the Children's Court of Queensland. So I think judicial officers cognizant of that are going to be really reluctant to transfer matters back to the Children's Court constituted by a magistrate, contrary to the views of the 17-year-old client. So you need to have those views ready and to be put before the judge at the time that he's considering that. In terms of the logistics of how that's going to work, it's understood that as much as possible, courts will try to resolve transferred adult matters on the day that they're mentioned and constitute a children's court. And I understand from speaking with Youth Justice that each court officer from each Youth Justice Service Centre should be aware of every 17-year-old who is appearing in the Magistrates Court from the 12th of February, and as much as possible, Youth Justice Services will attempt to have an officer from Youth Justice present at court in the event that the matter is able to be resolved. So in Brisbane, where there has been an allocation of an additional Children's Court magistrate in response to the amendment, there will be a duty solicitor available every day, and it's anticipated that the matters that are transferred from the adult court may be transferred on that day and may be dealt with either by yourselves, if they're your client as a practitioner, or by the duty solicitor who is at the Children's Court on that day. Outside of the Brisbane Children's Court, practitioners might need to familiarise themselves with the approach that's going to be taken in their individual jurisdiction. So, as most people will be aware, it's the usual practice in the Children's Court to have a youth justice worker present when matters are going to be finalised. If a court has an offence for which a child cannot receive a supervised order, that is an order that an adult cannot receive an order of imprisonment for, it might be that the court is actually willing to deal with the matter in the absence of the youth justice worker. And you might be able to just deal with it, ask the court to constitute a children's court. They'll do it there, even if a youth justice worker isn't there. There might be also instances, I've just got a question here that I might just see if I can answer at the moment. It says, we've got a question from Kate Louise, who's asking whether it depends on the age of the defendant at the date of the court appearance rather than the date of the offence. And yes, that is right. So it's actually going to depend upon whether a young person was 17 at the time of commencement, rather than because it's rather than the date of the offence. Because if they're actually 18, then the matter will not be transferred. So yes, it'll depend upon the age of the person now as to whether the matter would be whether they're eligible to be transferred or not. So in terms of getting those youth justice workers there, hopefully they'll be able to be there. My advice would be, if you've got a 17-year-old who's going to court, call your local Youth Justice Service Centre, check in with them, see if they're able to be there, talk to the prosecutor, see if they're in a position where they think that the court's that they're able to resolve the matter on that day, and then maybe check with the registry and say, I've got a 17-year-old, can you indicate whether the court's going to be in a position to constitute a children's court immediately on the same day, so that we might be able to transfer it and to deal with the matter there and then, if of course you want to get the matter resolved on the day. Practitioners who have clients who are actually remanded in custody, so if you've got a 17-year-old who's remanded in custody, you of course need to be alert to the fact that there'll be a change of circumstances by the fact that you're transferring jurisdiction, and that change of jurisdiction may of itself give rise to a change of circumstances that may then enable a bail application to be made. So I can talk from my own experience. I've got a 17-year-old currently remanded in adult custody. The matter will be mentioned on Monday. I've spoken to the prosecutor because, in fact, of the change of jurisdiction, the change of considerations, provided there are some conditions placed in place, there's now been an indication that there will not be an objection to bail raised in the Children's Court. So practitioners need to be alert to that as well. Practitioners who are appearing on matters that have been transferred from the adult court for 17-year-olds do need to be alert to the fact that it's an option for a court to dismiss a charge because the young person could have been cautioned or indeed referred to a restorative justice process. So that's under Section 21, Section 24A of the Youth Justice Act, even though they were an adult at the time that the offence is alleged to have been committed. So essentially what that's saying is you could still ask, saying, oh look, this is a young person who's a first-time offender, should have been diverted rather than being sent to court, and the court, it's still open for the court to dismiss the charge under those sections. So practitioners do need to be alive to that fact as well. But if you do have a matter that is transferred over, Section 81 of the regulation deals with the issue of the admissibility of evidence. So if you've got evidence that was obtained before the commencement of the proceeding, before the commencement of the amending act, so prior to the 12th of February, when the matter was in the adult jurisdiction, then that evidence that might otherwise have been inadmissible because the matter is now in the children's court will be admissible. So provided that you are complying with the police, were complying with the law prior to the 12th of February, then that evidence will still be admissible when the matter gets transferred to the children's court. So if you've got a young person, for instance, who's been interviewed without a support person for a matter that was commenced prior to the 12th of February, then that statement may still be admissible in the children's court, even though now, because of Section 29 of the Youth Justice Act, it wouldn't be admissible normally in a children's court matter. There are some questions about the wording of that act, but I think that any evidence that's obtained after the 12th of February, then I think the provisions of, when you read that Section 6, which said the Police Powers Act comes into place as at the 12th of February, it applies to 17-year-olds as if they were a child as of that date, then I think that all the any evidence that was obtained after the 12th of February, then the usual protections that would normally apply to children will apply to that legislation, will apply to that matter. In addition, that's essentially the thing to remember. If you've got a matter on foot for a 17-year-old, as at the 12th of February, the next mention in the adult court, that matter will be transferred to the children's court jurisdiction. There are some exceptions to that. The exceptions include, if you've got a matter before the Supreme Court, then that matter will stay in that jurisdiction and it will just be as though it was committed to that jurisdiction pursuant to Section 95 of the Youth Justice Act, so there's already a group of Supreme Court offences that have to go to the Supreme Court. If you've got a trial that had started before the 12th of February but it hasn't finished before the 12th of February, then the court has a discretion to stop hearing it if they think it's in the interest of justice to do so, and send it to the children's court to be heard. If the court has a concurrent jurisdiction, so for example, all Queensland magistrates have the authority to hear children's court, to act as a children's court magistrate, then they can continue to hear that matter and decide the proceeding as if the person were a child, so just continue it in the children's court. And if they don't decide to do that, so if the judicial officer says, well, I'm not going to stop it, I'm not going to continue to hear it as though I'm in the children's court, then they just continue to hear the matter, but if the person is convicted, the matter must then be transferred to the children's court for sentence. So the matter gets heard in the adult court, but gets transferred to the children's court for the purpose of sentence. In considering what option practitioners want to advocate for, you might be conscious of the fact that, of course, the children's court is a closed court. They're just things to keep in mind. Other matters that don't get transferred automatically at the next mention in the adult court would be if you've got a part heard committal, if you've got a Section 590AA hearing on foot, if you've got a directions hearing or something of a similar matter, something of a similar nature is the wording of the regulation, then the matter continues to be in the adult court until that issue is resolved, and then the matter will be transferred at the conclusion of that hearing. If there are matters for a breach of bail under Section 29(1) of the Bail Act, that act doesn't apply to children, and so consequently that matter will be deemed to be withdrawn at the next mention. So it will still get mentioned, but the matter will be deemed to be withdrawn. However, practitioners should be alert to the fact that the regulation does still allow for an application to be made pursuant to Section 30, subsection 1, to apply to revoke the bail or to vary the bail. So the prosecutor is still able to do that, but the offence itself will be withdrawn. And similarly, if you've got a breach matter for a community-based order, so if you've got a breach of probation, a charge for breaching probation or a charge for breaching a community service order against an adult, so an a charge under section 123(1), then provided the person was not convicted of that before the 12th of February and the matter remains alive, that matter will also be deemed to be withdrawn, because it's not an offence under the Youth Justice Act to breach a community-based order. There are consequences of breaching it, but it's not an offence to do that, and consequently the offence of breaching that community-based order as an adult will be discontinued at the first mention after the 12th of February. Other matters that won't be automatically transferred will be if you've got an application to revoke an adult community-based order. So if it's already on foot, so if the corrective services have already made an application to revoke an adult order, that matter remains alive until that issue is determined. And once the issue is determined, if the person is 17, then that order may be treated as an equivalent youth justice order, but I'll talk about the applications of orders in a few minutes. There is another little provision that practitioners need to be aware of in the regulation, which is regulations 11 and 12, and that deals with matters where you've got matters that have been committed for 17-year-olds from the Magistrates Court to the District or Supreme Court, but an indictment hasn't yet been presented. So you've got matters that you're at that stage where they've been committed, no indictment yet. If those offences are of a kind that could be dealt with summarily by the Children's Court, so that means they're not those serious offences that are defined in Section 8 of the Youth Justice Act, then there is this provision that whereby the Director of Public Prosecutions or the client, so you as the practitioner, can apply to the court from where the matter was committed to reopen the proceedings. And at that stage, a request can then be made to transfer the matter to the Children's Court before a magistrate for resolution, and so it may be resolved summarily. It's still open to the court at that stage to commit it to the Children's Court of Queensland for resolution. However, it's also open for a practitioner to ask, look, this matter could be dealt with summarily now, and consequently ask for the matter to be transferred back to the Children's Court, to a Children's Court magistrate, in order that the matter can be resolved summarily. So they're the provisions that probably apply in relation to orders, to matters that are currently on foot and before the court. And they're the exceptions, the general exceptions that apply in relation to those matters that don't get transferred at the first mention. I'll now just talk a little bit about current sentence orders. So Part 5 of the regulation is the one that provides that all 17-year-olds who are subject to sentence orders at the time of commencement will legally remain on the adult order, but the order will be administered as though it's a corresponding order under the Youth Justice Act. And corresponding orders are actually set out in the Amendment Act, not in the regulation, although they're reprinted in the regulation as well. And corresponding orders are set out there in section 389 subsection 6. And most of those are pretty straightforward for practitioners. So an adult probation order, the corresponding order is a childhood probation order. An adult community service order, the corresponding childhood order is a community service order under the Youth Justice Act. Graffiti removal orders are the same as those. The corresponding order is a graffiti removal order under the Youth Justice Act. The length of those equivalent orders, remains unaltered. So if you've got a 2-year, if you've got a probation order that's longer than the period of time that could have been imposed by a Children's Court magistrate as a 17-year-old, when that order gets transferred across to be or when it's treated as a corresponding order, the length doesn't change. So they'll still have to serve, a 17-year-old will still have to comply with that for the same length of time that they've always, that the court originally imposed, even though that couldn't be given now. So that won't be ordered. That won't be altered. If there are some orders, of course, under the adult legislation that don't apply to children, and so orders that apply to adults, like banning orders and no contact orders, they just still apply, even though children can't get them if the order was made prior to commencement, it will just remain in effect for that 17-year-old. For the Safe Night Out orders, for those people who are affected by those, if you get a community service, the community service component will actually be treated as a community service order under the Youth Justice Act, and if they're breached for it, they will be breached as though it was an order under the Youth Justice Act. So essentially what happens if you've got one of these orders that's been transferred over or that's been treated as a corresponding order, then any future breach proceedings will be treated as though they are an order under the Youth Justice Act, and the breach proceedings will be commenced and carried out in the Children's Court. If there are breach proceedings for an adult order that are already on foot on Monday, on the 12th of February, those matters will remain on foot until they're resolved. So until the resolution of that breach proceedings. But if there is a further community-based order that's imposed as a result of that breach proceeding, then that will be administered as if it is a youth justice order. A term of imprisonment, if a term of imprisonment is imposed, then that'll be treated as an order of detention, because imprisonment, the corresponding order for imprisonment, is an order of detention. Practitioners might note, when they have a look at that list of corresponding orders, that there is no corresponding order stipulated for suspended sentences. So, but if a 17-year-old commits an offence during a period of suspension, a court can take no action. They can partially or wholly revoke that suspension period of imprisonment. And if they're in the community prior to the suspension, then that order of imprisonment would then be treated as a detention order. So they'd then be held in a detention centre rather than being held in an adult prison. There is no power now to extend the operational period of a suspended sentence. That power is not going to be given as part of the transitional arrangements. So that's how existing orders are going to work after 12 February. I'll now talk a little bit about the idea of what happens to young people who are already being held in a prison on Monday, 12 February, and what will happen in terms of those young people. There is a framework in the regulation around the transfer of 17-year-olds from prison to detention. This won't happen automatically. There's not going to be a big bus turning up to the prison on Monday to take all the young people over to the detention centre. There are certain young people who simply will not be eligible to transfer their order of imprisonment, or they won't be able to transfer their time in detention they won't be able to go from the prison to the detention centre. Those people will be those people if they have turned 18. So if you're currently 18, you're not going to be eligible. Or if you're going to turn 18 within the next 4 weeks, you're not going to be eligible to be transferred across to a detention centre. Or if you are serving a sentence that's going to require you to be transferred to an adult prison in any event. So even if you were to have your matter, even if you were to go across to the detention centre, if the length of your current term of imprisonment is such that you're going to have to be transferred back to the adult prison, that is, it's going to last past your, are you going to be past 18 and a half, then you're not going to get transferred either. So basically it just sort of makes a bit of sense that a young person doesn't get transferred over to the detention centre, then only to have to come back to the adult prison. If you've also got a remand, if you're also on remand and your next court date is less than 4 weeks away, you're not eligible to be transferred. Otherwise, so except for those situations, a person must be transferred from an adult prison to a detention centre as soon as practically possible after 12 February, unless it's determined that it's not in the best interest of the young person to do so, or because it's determined that it's not appropriate based upon the security and safety and well-being in the detention centre. So they're the considerations that are set out in section 263 of the Youth Justice Act. And there are a range of decisions that are stipulated in the regulation that are taken into account in determining whether it is in a young person's best interest to transfer, and those include the views and wishes of the young person, the availability of programs for them in the detention centre, the proximity of family, any sentencing remarks that were made, criminal history, and if they're Aboriginal and Torres Strait Islanders, the views and representations of the community justice group. If a decision is made to transfer a young person to the detention centre, then they must be given a notice, and there is there's the option then of an internal administrative review, and a copy of that notice should be given to the parent and the lawyer of the young person unless they require it to be given to another person. And on that application, that initial decision is stayed, and the Chief Executive must make a decision and communicate that within 5 days. There's also an external review process for judicial review or complaint to the Ombudsman, and legal advice for these matters can be obtained through that legal advice line at Legal Aid, that number that I spoke about before, 1800 LAQ. If the person is on remand, there is a requirement, of course, that the court be told that the young person is being transferred. So if a young person gets transferred, it's not that they're not going to be able to find him to bring him to court, bring him or her to court. So they're the issues in relation to young people in prison. The further issue might be about parole. So the equivalent, the corresponding order under the regulation for parole is a supervised release order. Regardless of whether a 17-year-old is transferred from a prison to a detention order, upon release from serving a prison sentence, they will be released on a supervised release order. So regardless of whether they get transferred from the prison or not, the order will still be, when they get released, they'll still be transferred, if they're 17, on a supervised release order. Under the Youth Justice Act, as most of you will be aware, unless it's been prescribed by the court that they should be released earlier, they must be released upon serving 70% of their sentence. That will also apply to young people in prison. So if you've got a 17-year-old in prison, they must be released at least by the time they have served 70% of their sentence. If they've got a fixed parole date, which is before that 70% time, they will be released on a supervised release order on the day that they would be of their fixed parole release date. So they'll be released on a supervised release order on that day. If the young person has a parole eligibility date before the 70% mark of their sentence, then they may apply for bail. They may apply for parole, and parole will then be considered. So they'll then go through the usual process if they've got an eligibility date. But once they reach that 70% mark of their sentence, they must be released as they would be as if they had been sentenced as a child. If there are proceedings on foot for a 17-year-old on the 12th of February to suspend that parole, those proceedings will continue to be determined under the Corrective Services Act, so just as they would be. But at the conclusion of that matter, if there's any subsequent parole order that's still in place, then that will be supervised as a supervised release order for the length of that order, and any subsequent breaches would be brought under the Youth Justice Act. Finally, in relation to appeals, if you've got a 17-year-old who's got an appeal on foot on Monday, that matter will remain in the adult jurisdiction, so that matter won't be transferred at the next mention until a determination by the adult court of that appeal. If an adult sentence is imposed and that person is still 17, that order will be administered as if it was an order under the Youth Justice Act. And if the person is in prison, his order will remain an order of imprisonment and not be treated as a detention order until the appeal is resolved, and therefore they will not be transferred until such time as that appeal has been determined by the adult court. Now I think we've got another question, which I'll just read out. It says, if their adult court date is after commencement and they are 17 at commencement but will turn 18 before the next mentioned date, what happens? Do we need to bring the adult matter on for an early mention? that'd be a very good idea, I think. If you can do that, that would seem to make a lot of sense. I think, in fact, that the provision, yes, I think that would probably be the most sensible thing to do. I'm not precisely sure of that situation, but that would seem a very sensible thing to do. Try and bring all of your 17-year-olds on, as quickly as you can. Get them into the children's court as soon as you can. I'm sure the court might be willing to accommodate that. I think they're all our questions. Look, finally, I just want to congratulate the Queensland Law Society in its advocacy for this reform and commend the government in this long overdue initiative. QLS, amongst others, has worked very hard and steadfastly on this reform issue. I'd encourage all practitioners to embrace and be prepared for this change and to endeavour to make this transition as smooth as possible. Use the resources that have been provided by Youth Justice. I think inevitably there will be some hiccups and some difficulties with this change. Patience and cooperation of practitioners in dealing with this will assist in making this long-held aspiration an effective reality. I wish everyone good luck.